Well, welcome to question 71, Injustice in Judgment and on the Part of the Counsel, and I am Dr. Thibault. This topic, as you've now heard a number of times if you've been going through it, is part of a larger series, is connected with primarily justice, and then commutative justice, which is the justice between individuals. Um, these are issues of injustice connected to towards words of injustice uh, related to commutative justice. If that doesn't make any sense to you, you probably have to go back to some of the previous videos of commutative versus distributive justice. This section is dealing with issues of the trial. We've dealt with unjust judges, unjust accusers, unjust defendants, unjust witnesses, and now we are finally on unjust defense attorneys. It's a fairly short section, but we're finishing up finally this section on uh, trials. There's four questions. All of these have had four articles to them. This one is no different. The first article is, must a lawyer defend the poor? This is kind of an interesting question. And It says ultimately the answer would be no. You're not lawfully required to defend the poor, but it would be an act of mercy if you did. If you think of the corporal works of mercy, the spiritual works of mercy, defending the poor, particularly the widow and the orphan, would be a particularly important thing to do as an act of mercy, but it is not required lawfully to perform the acts of mercy. And as he points that St. Thomas points out, uh, one cannot one cannot perform the acts of mercy for all people at all times. Uh, there's limited resources, so one can't be seeking out in the world looking for people to perform acts of mercy towards. Um, that's kind of not how it works. In particular, maybe within the church, there's particular religious orders that are dedicated to certain charisms where they do that. The Mercedarians, for example, for relieving slaves. So they might go out seeking slaves, finding slaves. They might not be in their backyard. They go looking for them. Um, Mother Teresa's order, looking for the poorest of the poor. You know, you have to go looking for them. But in general, the works of mercy are for the average person, particularly a lawyer, an attorney, would be if by reason of place, you come across somebody who's in need of your help, you can show mercy and offer to help them. That would be wonderful. And by reason of time, there's only so much time in the day. You can't for free represent everyone, but you could try to structure that into your system, where you could take care of the poor. But it's really by reason of time and place, not out of obligation. It's a work of mercy rather than obligation. And then he also says, if somebody, this is a time when you didn't need to have a lawyer to represent yourself. Yeah, I know now you don't either, but I think it was more common for people to be self-represented at the time of Aquinas. So if you can help yourself, then you should do that. And if somebody is close to you who can speak eloquently on your behalf, use that person. Or if there's a person who's in a better position, uh, then you don't need to help as much. If the more desperate the person is, the more there's a real need to get involved. If the person's already fairly okay, then you certainly don't need to jump in there to do anything. The question that comes up is the fitness of an advocate. Who can be an advocate? He says people should be not allowed to be a member of the bar, not be allowed to advocate for uh, two ways. One is impossibility, and the other one is when it's unbecoming. Um, the impossibility one is an internal part, which is if you're a madman, you've lost your mind, or you're a minor. I'm not even sure why you would have a minor try to be your lawyer, but if you had a minor to be your lawyer, they're just unfit. I suppose if somebody is a non-functioning alcoholic or drug addict as well, that would fit into that category. That there's some people who are unfit. He also then brings up other situations of being deaf and dumb, which may not be necessary today, but at the time, if your lawyer can't hear what's being said in the courtroom, then they're going to have a very difficult time defending you if they're deaf. Uh, Now that's less of a problem. You would have sign language. At the time, apparently, they didn't have that type of sign language. Then dumb means not able to speak, which um, your lawyer has to speak on your behalf. So if the person can't speak, then they're not a very effective lawyer. So it's not something against the deaf community. It's just at the time it would have been a hindrance to being able to be uh, a lawyer. Not so anymore because we have other means of communicating. Then there's the class of unbecoming, and it's unbecoming because they're either too high or too low, according to the standards. So those who are too high, he says, St. Thomas says, monks and priests, it's unfitting for them because it is really ultimately their job to be servants of the altar, servants of God. They should be worried about higher things than about civil laws and about earthly things. They should be worried about more heavenly things. So unless they are defending their own monastery or their own church, then they really shouldn't be getting involved. St. Thomas is a fan of the lawyer priest. Can see this. Some people go to their priest who's also a lawyer. I need you to sue my family because of something they did. Well, that's really not what a priest wants to be involved with, suing somebody's family over some domestic dispute. Right? A priest is there to counsel, to encourage, to pray, to work on forgiveness, work on reconciliation. Really, not to sue someone. That's kind of unbecoming of a priest. It's unfitting. It would be lowering their character to do that. Then the other one, it would be somebody who is blind, and he describes this as somebody with a bodily defect. So blind is different than deaf at the time. So deaf, would mean you wouldn't even be able to hear what's going on in the case. If you can't hear, if you can't have if you can't hear what the other side is saying, you can't respond, you can't effectively engage in the case. Blind is different. If you know the case in and out and you're blind, somebody could say something to you, you can respond. It's not an impossibility. It's just makes it more difficult. What if there's some type of physical evidence that you have to look at? Well, the person can't see it. It becomes a hindrance to being able to effectively defend somebody in a court of law. So put blind in there as well. Likewise, today there are other ways of getting around it. In the Middle Ages, probably more difficult. And then he described the unbeliever or the fellow criminal, which he calls a defect of the soul. So if a person has low character, the person is a criminal themselves, then they would not be. It would not be becoming of you to go into a court of law with a notorious criminal as your defense. That would probably look bad on you. That's who is defending you. Although St. Thomas points out that unbecomingness is not the same as impossibility. Unbecomingness can be outweighed by necessity. If all you can get is a priest, if all you can get is a blind person, somebody with a physical defect, if all you can get is somebody who was a criminal, if it's better than nothing, then it can be done. Although you should never have a child as your lawyer, never have a madman as your lawyer, because that's only going to hurt you. Can an advocate defend an unjust case? Now, this is kind of confusing because in one way, no, and in another way, yes, but he doesn't really talk about that second way. Under our current system, everyone is due representation. Even the most guilty person on the planet still should have a lawyer, and we don't consider that unethical for a lawyer to represent that person because a case should still have due process. There should still be rules of evidence which are followed, rules of witnesses being called that are followed. There's still a certain procedure that takes place in the court, and everybody is owed a chance to be properly represented. Now, if the person is guilty of sin, well, that should come out, and then the person will be found guilty. But if the person isn't properly represented, then it could be a mistrial because of some type of error. The person could appeal because justice wasn't done correctly and fairly. So actually, what preserves justice is a lawyer on both sides. That's our current standard. That doesn't seem to be what St. Thomas is saying. He's saying it's unlawful to cooperate with in any evil deed by counseling, helping, or in any way consenting. He also says, if he knowingly defends an unjust cause without doubt, he sins grievously and is bound to restitution of the loss unjustly incurred by the other party. So that the other party should be able to sue the lawyer on the other side for representing the client. That we would be very much against today, that idea. He says if you didn't know at the beginning, then you're not, if you didn't know, you're not responsible. But if you didn't know, but as the case goes on, you get to realize your client is guilty, then you should find a way of withdrawing without hurting your client or making public what was disclosed to you. This still doesn't seem to be quite, it doesn't go along with our adversarial system of justice that we have today. Although where I could see that it's still fairly applicable is if it's an unjust case rather than an unjust person that you're representing. So let's say the case is to defraud somebody. You found some way of defrauding somebody through a legal system. Let's say you know that your client constantly is suing everyone from slipping and falling. They just sue people left and right. Well, that isn't just you representing a person who's unjust. You're actually you're pushing forward a cause, a pattern of unjust behavior. Well, this is really in terms of a defense attorney rather than a prosecution. So I'm not sure. Usually those types of abuses are the prosecution or the plaintiff rather than the defendant. But I could see that. And he does point out here as well in one of the objections, in responses to the objections, the idea of, there's certain things a lawyer doesn't need to fully disclose, private confidential information he has. That's perfectly fair, but you shouldn't do things like call false witnesses. You shouldn't do things which are unjust on its face in order to try to get your client to win. But that is different than representing. I think today the system of adversarially, both sides presenting the facts and a case to their fullest ability on both sides and letting the court determine the outcome is probably better than somebody standing there unrepresented. Are the advocates paid? This is the fourth and final issue, and it says yes. Yes, they can be paid because nobody is required to provide legal assistance for someone. Because you're not required to, then the person should be able to sell their skill, their talent as a lawyer, their counsel, and their ability to make pleadings. So if they can do it, then they should do it. And he says, if this idea is, well, anything that could be done in mercy should be done in mercy rather than through economic means. He said, well, if we were to really follow that all of the way, then nobody would ever sell anything, right? If the farmers could give away the crops instead of selling it in the grocery store, then they shouldn't give away the crops. Everything should, teachers should give away education for free, then why should they, then they shouldn't be paid. Well, then nobody should be paid for anything. That would be the breakdown of the system. As an advocate shouldn't extort somebody, and he gives the example of a doctor. Doctors, they shouldn't extort somebody. They shouldn't come and say, "Oh, I'll help you, but you got to give me $1 million." You should be paid with accordance with the commendable custom of your country, of your place. So whatever is aligned with what's customary that's what the person should be paid. In conclusion, to throw it all together, again, fairly simple, straightforward system. An advocate is not required to take pro bono cases, but may and should out of mercy, depending on time and place and availability. An advocate should be effective and not be incompetent either by being too high or too low. So a priest or monk might be too high and a madman might be too low. You're aiming for adequate competency. An advocate should not aid in an unjust case. It's still a little bit unclear if that means just a person who's clearly guilty or an actual case that is intended to create fraud. The latter clearly being more condemnable than the first. And an advocate can be paid for the work done, which he can do because it is a free arrangement and one is not required to be a lawyer and to provide free services. Therefore, they should be able to charge moderate prices for their services. That's all we have now for the legal system. We continue on with issues of commutative justice in terms of words as we continue on with this, but more interesting ones than court procedure from the Middle Ages. See you next time.